Hello, classmates and professor. Before I give my rule or my vote, shall I say, on the impermissible release of Jennifer's information, first off, let me begin by explaining what privacy is. Privacy is a person's expectations to keep or control access to his or her individual space, as well as knowledge of certain information. It also enables a person to limit who has access to their information, for what purposes it is going to be used, and for how long. Their right to privacy is the legal right to control access as well as exclude others from intervening. Now let's talk about confidentiality. Confidentiality is the ethical and legal obligation to refrain from sharing information about other individuals without their authorization. The ethical principles of the American Medical Association in 2003 detail that the physician should not reveal confidential communications or information without the consent of the patient unless provided for by the law or by the need to protect the welfare of the individual or public interest. Once an institution or person is entrusted with otherwise private information or access, the duty of confidentiality restricts the disclosure of that information without permission or strictly defined necessity. The state of California, which is where this case is being held, also has the Health and Safety Code, where Section 1280.15 that was adopted in 2007 requires that a clinic, healthcare facility, home health agency, or hospice establishment prevent unauthorized access to medical information. The Health Insurance Portability and Accountability Act, or HIPAA, is the federal law that protects patients' health information also. The case of impermissible disclosure of Jennifer's health information noted that a subpoena without a court order was presented. According to HHS.gov, information is only disclosed if the notification requirements of the privacy rule are met. Evidence must also be provided before responding to the subpoena that there were reasonable efforts to notify the person on whom the information is to be disclosed, or a qualified protection order for the information from the court must be obtained. Jennifer's health information was obtained for her ex-husband's purposes. There was no court order with the subpoena, and no qualified protection order was obtained from the court. Also, contrary to the privacy rule protections for information sought for administrative or judicial purposes, the hospital failed to determine that reasonable efforts had been made to notify Jennifer of the information request, nor was evidence provided showing that the parties seeking the information made reasonable efforts to secure a qualified protective order. Privacy rules and protection of patient health information laws are designed to be enforced by state, local, and federal organizations. If patients cannot entrust their hospital care providers or the healthcare facilities with their personal information, patients are going to be reluctant to share vital details with their providers. This reluctance may lead to a decreased quality of care for the patient. In Jennifer's case, which entailed divorce proceedings, all of her and her family's medical information was released to her ex-husband. There is no explanation as to why this information was needed. Also, the ex-husband could use the information for ill-gotten gains. Based on this information, I must rule for the plaintiff. Thank you.